everyone, this is Amina Ansari. Welcome to HW News English. Big news coming in. The Supreme Court of India has reserved its verdict on petitions challenging the abrogation of Article 370, which granted a special status to the state of Jammu and Kashmir. The Constitution Bench that heard and reserved the matter comprised of Chief Justice of India D.Y. Chandrachud and Justices Sanjay Kishan Kaul, Sanjiv Khanna, Bhushan Gavai and Surya Kant. The proceedings in the Supreme Court on Article 370 matter witnessed extensive arguments and discussions with the petitioners, buttressing on the permanent nature of Article 370 and thus the special status of J&K, while the centre and other respondents emphasizing that the provision was always meant to be temporary and that its abrogation was the ultimate step towards complete integration of J&K with the Union of India. Senior advocate Kapil Sibal led the legal submissions on behalf of the petitioners in the case, followed by a strong lineup of other senior counsels which included Gopal Subramanian, Rajeev Dhavan, Dushyant Dave, Zafar Shah, C.U. Singh and Gopal Sankaranarayanan. The petitioners had brought up the requirement of consent from Constituent Assembly for abrogation of Article 370. They questioned the validity of President's rule which was in effect when the abrogation was made. Few pleas went back to the instrument of accession, while some highlighted the Supreme Court's ruling of 2018 that observed that Article 370 had gained a status of permanence. The Jammu and Kashmir State Reorganization Act was also challenged, by which the state was bifurcated into two union territories with effect from October 30, 2019, arguing that there was no power with the centre to reorganize the state into two UTs. Some petitioners, which included parliamentarians from the National Conference Party, Kashmiri citizens, former bureaucrats and various organizations, claimed for the first 9 days that Article 370 was an embodiment of a constitutional promise given by the Dominion of India to the princely state of its unique status despite its accession, and argued that Article 370 assumed the status of a permanent provision which could not be nullified by the President. Countering this argument, the centre, through the Attorney General and Solicitor General, underlined that Article 370 was not an embodiment of any special status to J&K, but was only a stopgap arrangement in the process of complete integration with the Union of India. The government also defended its authority to reorganize the state into two UTs, contending that there was no constitutional bar against redrawing boundaries of a state that could promote keeping the integrity of the country intact. At the end of the hearing, the Constitutional Bench also sought to know from the centre to indicate if there was a time frame for granting statehood to Jammu and Kashmir, underlining that the restoration of democracy in the region was very important. The centre came back with a response on August 31st, refraining from committing to an exact time frame for granting statehood to J&K, even as told the court that the Legislative Assembly election for the Union Territory of J&K could take place whenever the state and the Central Election Commission decides. That's all for this news report. For more such news and updates, subscribe to HW News English.